closely at that. So this is a slide that's really near and dear to our hearts, because what it is it's the US immigration law system in a snapshot. And I always like to show this to our human resource friends so that you understand the thought process of the US immigration lawyer, and how we have to think about possibly getting some type of status or some type of work authorization for your staff. So I'm going to kind of rifle through this because we have so much information that we need to cover. But basically what this is a spectrum. And the spectrum runs from left to right. And this is sort of what I would refer to as the life, sort of the life cycle of the US immigration laws as it applies to a foreign national. So first, on the far left-hand side, we have individuals who don't have status. And you would think that maybe these individuals don't have any options, but I get calls on a daily basis. Lutka and I both get calls on a daily basis from individuals, from companies who have individuals who they all of a sudden realize may not necessarily have status. And obviously the first thing that comes to our mind is the ethical question of whether or not we can deal with them through you as the employer, because if you know that you have an individual who's not authorized to work on your on your payroll, you really are supposed to let them go, of course, because otherwise you have a violation of the Immigration Reform and Control Act. So again, going back to that, it's illegal to knowingly hire or retain an unauthorized worker. But we also find that in a tremendous number of cases, individuals are companies, because these individuals have, let's say, been so loyal for so long, are willing to go ahead and do the sponsorship sometimes. And if they do that, can they do it is really a question that we grapple with. And we guide the employer, the HR, on how, if you're going to do it, it can be done to insulate yourself as much as possible from potential exposure.
And David, we see it quite often. I mean, it may sound surprising, but there are many companies that discover they have employees for 20 years, and now let's say they sign up for E-Verify. Now they discover that this individual doesn't have status. So we actually see it quite often. And then we explore exactly all of these options, Daca and U-Visa and so on. So, it's not just for the family-based immigration. It actually happens quite a lot, especially for those companies that have employees for a really long time. And, now they caught it, that these individuals don't have immigration status.
And it's really no surprise, given the fact that even in the Citizenship Act of 2021, there's this pronouncement about the fact that there are 15 million unauthorized workers in the United States. So these individuals have either come here illegally, or they could have come on normal visas and then fallen out of status for whatever reason. They may have fallen out of status not because of anything they did, but they may just not have known what they were supposed to do, and this happens. So can those situations be rectified? We believe that it can. We just have to analyze the situation, and this is not a cookie cutter analysis. We need to look at what the person's background is, all different types of things. Where are they from? Do they have family here? There's a whole variety of factors that we need to analyze to determine whether or not there are potential benefits. So if you take a look at individuals who have no status, we first look at individuals who have potential for Daca, the Deferred Action for Childhood Arrivals. Those are the dreamers. Lutka told you about them before. U visas for individuals who are victims of certain crimes, who have come to the United States and either been the victim of a crime or assisted law enforcement in being able to root out the evils of the world, and they can actually get status while they're here without having to depart. 245I is a special program. It was a limited amnesty that was run back in the Clinton administration for individuals who made qualified filings prior to April 30th of 2001. And the nice thing about that is maybe many of the folks that you might encounter don't necessarily qualify themselves having made that filing, but their family members may have made qualified filings and they can inherit the benefit. So believe it or not, we probably on a monthly basis see a couple of folks who could potentially benefit from 245I. And then you have asylum seekers, and these are individuals who come to the United States who have a credible fear of persecution. As long as they file within 1 year, they can get work authorization and they can be working for you. Now, Under non-immigrants, these are individuals who have an intent, there's what's called pure non-immigrant intent, which is individuals who intend to return home. And then you have dual intent, right? So Lutka, tell us a little bit about non-immigrants and how our HR managers might want to look at potential non-immigrants. And what is like the normal trek that a student, who let's say has temporary work authorization may take to get longer term work authorization?
So typically the companies would see students, you're right, David. That's a perfect example because they would hold optional practical training. So they would have work permits. So that's usually how the companies are going to find, students working for them with the work permit. But that's only for 1 year. In some cases can be extended for another 2 years. But it is a pure non-immigrant visa status. So it doesn't really lead to a green card. And the normal procedure would be to switch them over to a dual intent visa status that gives them the long term work visa and then eventually green card. So typically it would be the H-1B, in some cases L, potentially if it works out, that's an intra-company transferee, O, it's a good option. These are very classical and typical dual intent visa status categories. Typically what we would do, the HR that has somebody on OPT, the student, they would provide potential job description, maybe the status, the immigration status, the resume, and then we'll look at it, what options potentially would work for that individual. Once they have that long term work visa status, only then the employer can start thinking about the green card. So it's very important to understand that, if you have a student or you may have a visitor on a B1 as a business visitor, and you're interested to keep them, sometimes, we get questioned, how do we apply for a green card for this individual? Well, then we have to take a step back and just look to see, well, first, what is the non-immigrant visa status that we can change them to? And as I said, H-1B is a perfect example. And obviously, once they're here for long term, then we are looking on an immigrant side, and whether it's a family-based immigration or employment-based immigration. Oftentimes, you may have an employee, you're thinking about doing the green card, they already have the H-1B, and they get married to US citizen. So that may be easier option, and you may support the family-based immigration, or they already have a parent that sponsored them for the green card. And then you have 5 different categories for employment-based immigration.
So Lutka, let me just see if I can understand something, because I have this happen all the time with my human resource managers. They'll come to me and they'll say, listen, we're thinking about doing sponsorship for this foreign national. We're not sure what type of green card, employment-based green card we should do, but the person's married to a US citizen. So what should we do? And so what would your advice be?
Well, my advice would be, it would be the best to just proceed with the marriage case because it's probably the shortest as far as the timing.
Least expensive.
Least expensive. There are some circumstances, I've had cases, believe it or not, that, for some reason, the foreign national didn't want to proceed with the marriage case.
Yes, exactly.
It's very rare, but I've had it happen. And then we ended up doing employment-based case anyway. But if you have—
Can you proceed on both tracks?
Yeah. And just see, which one goes first. So even for the employment-based categories, we see it quite often with the companies. Our Chinese or Indian clients typically pursue both EB2 and EB3 categories to see which one moves quicker, because we talked about it that, sometimes it takes 10 years, 15 years. So they could have several categories and just see which one goes faster.
Exactly. Before you go to naturalization or citizenship, I just want to quickly point out to our HR folks who are on the webinar that B is very interesting because you guys may have foreign affiliates. And if you're bringing an individual into the United States as a B1, okay, which could be that the B1 is subsumed within ESTA, okay, where they come in on an ESTA for 90 days, that's a B1 type of entry, or if they're coming in from Canada or Mexico, they're coming in on what's called the US MCA, and that's so they can come in on a B1 type of entry. In Mexico, they have to get the visa stamp, but in Canada, they can just come in. And then, so they can come in and they usually get 6 months. But it's really important to understand that, first of all, B visa holders cannot work in the United States. Okay, so that's number one. And number two is that when they come in, we don't use the word work. They're actually coming in to perform services in the US on behalf of the foreign affiliate. Okay, and so it's really important to make sure that, again, you don't use the word work, and you'd want to coach your individuals who are coming in who are employees of your foreign affiliates. If they're coming in to do something in the US, I guess the first thing you want to do is just take a look at what exactly they're doing, because you want to make sure it's not quote
And if it
unquote
qualifies,
hands-on.
it's
Right,
a very thin, it's a very thin line between the
Exactly.
actual work and B. And we've seen a lot of issues that those B1 applicants are stuck at the border or the port of entry, and sometimes they even get expedited removal because of the wrong terminology. They're going to
Exactly.
say, I'm going to work, or I have a manager here. You know, they just don't explain themselves properly. So it's very important to coach them. You're right.
Exactly. It's very important to let them know that they should be saying, we're coming to the US to perform services in the US on behalf of our foreign affiliate, and to carry a business card from the foreign affiliate, and possibly to carry a bunch of other documents to show that they're on the payroll of the foreign affiliate. Lutka, naturalization, after the client has been with us on the green card, either through family-based or employment-based, then they can apply for naturalization, right?
Yeah, typically it's 5 years. If they're married to US citizen, then it's 3 years. But obviously it's usually not the company that would deal with it. That's up to the individual, whether they don't have to, they can just stay on the green card forever. We have some individuals that, because they're worried they're going to lose their own passport or nationality, citizenship, they don't want to proceed with citizenship. So that's their own.
So before we go to the next slide and we start into the H-1B arena, I just want to point out to all the folks who are on this webinar, this is super important, is that if you take a look at the M274, which is the employer's handbook, which is the 100 and I think 30-page document now that explains how to fill out a 3-page I-9 form. If you take a look at how it's designed, it's very interesting, because what it does is it goes through these various non-immigrant visa classifications and the immigrant visa classifications and naturalization. It shows you the documents that are associated with these various classifications. So essentially, the reason why we're showing you this slide is so that you can get a good lay of the land and understand when you're going through and learning the information in that M274. All that information that's designed to help you understand how to verify work authorization is keyed to this chart. So if you understand the chart and you understand the various types of classifications, then you'll understand what needs to be looked at for each particular individual to be able to verify their work authorization. Okay, I'm off my soapbox.
Okay,